Number 51, People versus Robert Whitsett and Patricia McDaniels. I have 2248 F, 2246 FC.
Good afternoon, Your Honor. Amy Weiser, appearing on behalf of the people in both of those matters. Mr. Goldstein just stepped out. His jury had a question, so he's not in the room. He said he would be right back.
Well, Mr. Goldstein is not technically on the docket today. Never filed anything, but I did.
Didn't have a notice of hearing.
I mean, and I believe Ms. McDaniel is here.
She is. She's just.
So I'm not barring him from coming in today, and I think he's here. So the question is, do we delay this or do we get started and talk about Mr. Whitsett and then go on to Ms. McDaniel?
Perhaps we could start with Mr. Whitsett, Your Honor, if that.
Okay, so let's do that. So what we have here is Mr. Bernstein filed a number of motions, and we listened to them. I don't know if it was last week or the week before. I think it was last week. And so I've had a chance to go over everything again. I did need to do some research. Do that. But in essence, I gotta tell you.
Thank you.
That I think I need to have an evidentiary hearing on the rape shield question. I mean, that's my conclusion based on all the research that I and we have done. So that's kind of where I am with that. Do you disagree with that for any reason?
The statute does call for an in-camera review, so perhaps more private discussion would be appropriate for this matter in a less public forum anyways. I wouldn't be against that, I guess.
Riser, what are your thoughts?
And I'm not opposed to that. As I indicated to Your Honor at the bench when we had a conference last week, it's a very unusual circumstance in that the victim is a minor in this case,
Right.
so she can't have a prior consensual act.
Right.
But the case law was not really definitive one way or the other. And my concern, as I indicated to the counsel and to the court in the pleadings, is some extensive cross-examination of the minor child about the sexual assault that was committed and that the defendant had been.
I need to stop saying that shit. There was no
Yeah,
fucking
yeah.
sexual assaults with my daughter. So y'all need to stop saying that. And ever since I'm staying in this prison, y'all gonna get sued every minute, every second I'm sitting in here. Because first of all, she was never sexually molested in my motherfucking case. So y'all need to stop saying that Andrea Bonner coached
Ms.
her.
McDaniel?
I don't care. Miss Bonner coached her because I didn't get her no stimulus money. So now I'm sitting in prison over something I didn't do. This is what you call defamation of character and perjury and making a false police report.
Okay. Carry on.
So with respect to the issue of the prior assault against the victim and her being cross-examined on that.
All I'm literally telling you everything that you guys looking at all that. I think that my conclusion is that there needs to be a finding by me as to whether or not this is, and I think it needs to be more than a motion. So what I'm going to propose is that, so there's a couple things when we were at the bench too. Mr. Goldstein, come on up. We did have to mute your client. But couple things that it is clear to me that I need to have this hearing and I want to get that on the books. And now that Mr. Goldstein is here, Mr. Goldstein, you're killing me. You're not filing motions. So like I'm technically not going to let you withdraw. I don't know if you want to still, but I thought that was kind of the message last week. Notice
You're doing the trial.
so
The motion was filed like a month ago, Your Honor. It's getting it on the docket we've had a problem with.
I know, and it's still not on the docket, but Ms. McDaniel has been writted, so I'm not granting your motion today, but I will likely grant it. And so that's going to delay the trial. There's no question about that. I'm not doing anything today. So what I'm going to propose to you is that we schedule during the week that we were going to have this trial. And we'll have to look at what's.
Sure. Judge, I'll have suggestions, recommendations for ways that evidence can come in that can be very tactful. And I think will make it a lot easier. I can save those for the evidentiary hearing.
So let me offer you a possibility. 26th, which is that Monday, 9:30 in the morning. I'm just going to get them out there. We could go 27th, really anytime in the morning, or June 28th, anytime in the morning. I don't know if there are other here. I mean, I know you guys are busy, so I'm putting possibilities out there that were scheduled that week for the trial anyway. So
I would say June 26th, and we already have a calendar for the trial. I could do Monday morning. Tuesdays are in-person exams, so that's a bad day.
So, I mean, you guys would have been here.
Wednesday before your 1:30 docket, we would do it like outside of presence.
Yeah, we'd be doing it sometime in the morning. I don't have another matter.
Could we do it a little bit later in the morning, Your Honor? I have to be in Adjournment in the morning. I could check back here.
No, because I have a hearing that once I decided this, I'm continuing a trial starting at 11. So, I mean, depending, we could do it at 10 if that helps.
We can, I'll just adjourn the other thing, Your Honor. It's okay. Okay, so June 26th.
Yeah, so we'll go June 26th at 9.
Could we approach before a break just so I can perhaps get some guidance on the evidentiary hearing to make it more streamlined for when?
Sure, but
Yeah.
let's wrap this up in terms of,
Okay.
so, Mr. Goldstein, stop killing me and get whatever you get scheduled on any potential day. I'm not promising you I'm going to let you out, but I know that this is not the day of trial. And I know that, I understand your client may have some difficulties and I've heard her today, which is likely to grant the relief you're requesting. But just so that we're clear, that delays everything unless we separate the trial.
Judge,
That's kind of where we are.
I promised Ms. Reiser last time when I talked to her that I would hand deliver the recipe for the next one.
So again, just make sure that it's a Wednesday that I'm here and we can get Ms. McDaniel written so that she can hear it. But we'll go from there. Okay?
And so are we then canceling the double jury on the 26th?
Yes.
Are we rescheduling it for July 10th, Your Honor?
I'm not going to do anything right now. It would actually be impossible for us to do this. Because and if I were to grant Mr. Goldstein relief, that's what I'm saying. And we're not, I don't think we can call enough jurors for July 10th at this time.
And I think the court had been toying with the idea of severing. I would be in favor of that because Mr. Witt said.
If we were to do that, and I'm not saying we will, there would be time for me on the 26th we would have a jury, we would have we'd have enough jurors to panel somebody at that point, the juries.
On July 10th?
So I'm not sure of the answer to that. And I know we talked at the bench and that hasn't really been sort of put on the record in terms of a real outcome. But depending on what happens on the 26th, that will impact what happens with Mr. Whitsett next.
Do you want any pleadings I'm opposed to the severance. I would like the cases tried together. Do you want anything on that?
In terms of there's probably no clear bright line law on that. So I think I understand why you want them together. And I am very cognizant of that, of not having the witness testify twice. I'm certainly well aware of that. And that's really what would cause me not to do it. So again, as I sort of mentioned on the bench, I think last week, that there might be some advantages. We no rush to continue with Ms. McDaniel as defendant if we're seeking new counsel for her, if that's going to happen, because she's in custody and getting credit were convicted again, it would be concurrent. So, I mean, at this point, we could have a trial in 2 years. I'm kidding, but I'm just saying, there's no rush to that. So that I'm just putting out there kind of my thoughts about the minor child as a witness. Perhaps then there would be time to sort of put this behind her. I don't know. I'm still toying with that. So, okay.
Can we still approach her? And I just want to ask a couple of questions if I could, real fast. Okay.
So, after the bench conference, if Ms. McDaniel has something constructive to say, we can unmute her. Okay. So.
Looks like they both.
What was the question?
I All right, so we are back on the record, and we'll just say in both matters, bench conference counsel for the case with Mr. Whitsett. There was some discussion about the procedure, the content of the evidentiary hearing. There's a concern, Mr. Whitsett, if you're not sort of your lawyer filed a motion, he filed an appropriate, well, you're not even listening to me, so, okay. So for the record, Mr. Bernstein filed a motion which was appropriate in this case, and these are complicated cases, as Ms. Reiser pointed out at the bench, that there's not bright line rules from the Court of Appeals of the Supreme Court on these issues, and I think that's a compelling reason for me to make a record of what we're doing in this case, depending on what happens post matter. So we are going to have that hearing at 9:30 on June 26th. I do want to just reiterate that if we have a double jury trial, then there's not a possibility of proceeding on July 10th because we already don't have enough potential to accommodate. Possible could have a trial on the 10th, full jury. Talked about the ramifications of that and what might happen from. And I'm not promising you anything, Goldstein, but I'm going to hear from your client in a second. Hold on, Ms. McDaniel. It is probable that I will grant this motion. I'm not for sure. It's probable, but that will then drive again new dates because has the right to counsel. If it's going to be a double jury, that would mean that her new lawyer has to be up to speed, prepared to try the case with Mr. Bernstein. So we've got a lot of things play right now in these two cases. I have some concerns about double jury this time because of the prior matter and Daniel's jury and what we need to separate them. So there's a lot going on here. So,
Judge, I'm sorry. I'm looking at the screen and both defendants are acting like they can't hear you.
well, I'm going to guess Mr. Whitsitt can't hear me because he appears to be screaming. I don't know that that's true, but
Oh, no, they're right. That's in terms of us hearing them, but they're acting like they can't hear us. Okay, they can?
Transport.
Oh, okay, okay.
so, all right, Ms. McDaniel, let's take you off of mute and give you an opportunity to speak, okay? So you're going to need to get the officer in to turn mute off.
Your Honor,
Hey, your breaks.
everybody just calm down. The
This
judge,
is some
the
hot
judge
water.
is talking to you now. The judge is talking to you.
That's taser doing my thing. Turn around and listen.
Well, what the heck? Mr. Whitsitt, what do you want to say?
I'm sorry, Your Honor. I'm sorry, Your Honor.
That's okay. Go ahead. Go ahead. What do you want to say? What I just was saying on the record is that we're going to have a motion, you're going to have a hearing on June 26th at 9:30 a.m. That's one thing that's happening. It's possible that your trial date might be July 10th, although I can't promise you that. But I'm just letting you know that that is a possibility, and we'll know on the 26th whether that's going to happen or not. And then if it isn't going to be then, and I let Mr. Goldstein withdraw as Ms. McDaniel's attorney, then your trial is going to be in the fall because we got to get a new lawyer in here to do it. So I don't know the answer to any of this stuff, Mr. Whitsitt. I know you've been sitting in there not getting any credit because of, I think, parole issues. I think.
I'm
I think.
on parole.
But I'm just saying that we don't know yet what the situation is, but you are coming back on the 26th for a hearing, and it's possible that your trial might go on July 10th. That's all I know right now, okay?
May I please, as I sit here pushing 3 years, Your Honor, I'm being accused. I understand the severity of everything that's going on. I really do. I'm tired of sitting here, man. If there's if anybody could listen, I asked to be released to a tether. I'm on parole. I can't sit here no longer, Your Honor. I'm getting in trouble. Officers becoming more. There's nothing going on for me in here. There's nothing going on for me. I'm pushing 42 months. 42 months of being in here for some accused, Your Honor. I would never do nothing like this. I asked for a bond just to see what my parole will do. I'm on the bond. I don't oppose an issue with anybody, with nobody. I'm not a threat to nobody. I have a criminal history, true that. But it was all.
Well, we're gonna, I mean, I can't let you out today, Mr. Whitsitt, but you will be at the hearing on the 26th, really about 2 weeks from now, a week and a half. So sit tight. We'll have you back here on the 26th.
Yes, sir.
All right. Ms. McDaniel, can you hear us?
Yeah.
Okay. I know you wanted to say something. Go ahead.
Yeah, one, I do need to get Goldstein off my record, off my case, for one. For two, I'm sitting in prison over something I didn't do either. We all getting accused. Let me say this. I'm a mother of 9 kids, okay? 9 kids and 6 baby daddies. 31 years old, never caught a criminal record ever. Andrea Bonner coached my daughter to even Goldstein know that
So I'm gonna interrupt you, Ms. McDaniel. You were convicted by a jury. So as far as I'm concerned, you did do that and you have rights to appeal. And that's all we can say. I have noted you want Mr. Goldstein off your case. It sounds like he wants off your case. So I'm likely to grant that. And so we're gonna get you a new lawyer. Okay?
Can you listen? How you gonna cut me off? I'm talking. I'm talking. I'm listening.
Well, I am gonna cut you off. We're done with this hearing. So we'll see you, whenever he files his motion, we'll see you back here, okay?
No, the fuck y'all won't. Now,
Okay, well,
Judge, may I ask what might be an obvious question? Given what she just said, given that Ms. Reiser has not indicated any opposition to my motion, can I just submit an order?
no.
Okay.
Well, I mean, and it's not like but because of the complication.
I understand.
Companions, I think I gotta have kind of a clarity and a record so that we know what we're doing. It does impact the other case.
Well, I understand. And as I said, I knew the answer, but I felt that.
Now that I've heard that, I again am less likely to deny your motion, but we're gonna need to sort of just have these sort of all on record, just so that they're.
That's fine. I just felt I had to ask, Your Honor.
Okay, fair point.
So when are you gonna press it up?
The,
Do you want her written down for the?
I do.
I'm gonna give you time. So how about either
Records for,
the 5th or the 12th, either one. You pick a date.
let's go with 9:15 on the 26th for the McDaniel matter.
15.
And then we'll do 9:30 on the 26th for Witset. Okay, sure.
The prosecutor's office cancels the writ or submits something.
I think the prosecutor's office will submit the writ to get her here from MDOC. So it'll be on Zoom. She'll be on Zoom. And I don't know about Witset. He could be on Zoom too, actually.
Okay.
Okay. Well, that was a humdinger, everyone.
Number 13, People versus Nolan Hearns Jr., 22799 FH.
Judge, I guarantee this one will be a lot easier.